Good morning. Welcome to day 2 of risk management training for construction contracts. This is Victoria Beal with the Ohio LTAP Center, and we're so pleased to be partnering with the Supportive Services section of the Division of Opportunity, Diversity, Inclusion at the Ohio Department of Transportation to be able to bring this training to you. We have Attorney Patrick Espinoza who will be delivering the second part of this training. Hopefully you were able to participate in yesterday's session. If you weren't, we will be sending out a link to the recording later, and I'll make certain that everyone who's registered for day 2 receives that link. A couple of housekeeping items. First off, there is a question box in your GoToWebinar panel, and we ask that you please utilize the question box to submit questions during today's presentation. Those questions will be read to the presenter so he can provide a response. We also have some handouts for you in the handout panel of the GoToWebinar box, and we ask that if you didn't download those yesterday on the webinar, that you go ahead and download them today. There will be reference made to some of the handouts in that box, so it'll be good for you to have those. Otherwise, we are going to get things moving because I know Patrick has quite a bit of information for you today. Are you ready, Patrick?
I am. Thank you, Victoria.
Thank you.
This is Attorney Patrick Espinoza. Thank you for giving me this opportunity, and I hope everybody found yesterday's presentation useful. We're going to jump right in because there is a lot of information to cover today. Again, please ask questions when you have them. There's also 3 handouts that we're going to be using in about 5 to 10 minutes here. That's going to be the sample subcontracting agreement, sample general provisions, and sample special provisions. So very quickly, we're going to go over a question from yesterday that was submitted. Great question. We're going to go over the sample construction contract, the sample general and special conditions, some other important terms, liability, insurance, and Department of Labor concerns, some red flags and contracts. We're going to cover changes, claims, breaches. Litigation concerns. We're going to go through. I'm going to go through the life cycle of a lawsuit, so you know what lawsuits entails. We're also going to do alternate dispute resolution. There are other ways to resolve disputes, and then we'll go over damages, liens, and then we'll end with risk management plans, crisis plans, and some miscellaneous items. So a question from yesterday was a very great question. The question was. More times than not, prime contractors will send us contracts that are extremely general and do not include our job-specific quotes. The question is, does adding to a contract the clause, contractor agrees to all terms and conditions, does that clause hold water legally? And this is a fantastic question. It's going to lead into perfectly to the first topic here today. And the short answer is generally yes, but maybe not because of the reasons you might think. Obviously, it depends on the contract language, but the language, contract agrees to all terms is very vague, and you can't make up terms after the contract is signed. So why is this so important? I'll shortly discuss that. A clause like that may incorporate other terms. This is called a flow-through clause. And while the language is vague, the specific terms and conditions can more than likely be found somewhere else in the contract documents or in the prime contract. That's the owner general contractor contract. So the specific terms are generally there. You just have to find them. And it goes back to what I was trying to hammer home yesterday. Know your contract. You have to know everything you're getting into. However, on the flip side, if the terms really don't exist and it is just that vague, this raises red flags, and there are some issues that might go to several points from yesterday. The first, if there were verbal promises made and whether there's a merger clause in the contract. Remember that a merger clause gets rid of any promises made verbally. They're not specifically written to a contract, so be careful with that. The second is just having vagueness in contracts. That's one of the big red flags that you always want to look for. The more vague a contract is, the more likely there will be disputes. In practice, it doesn't always go this way, even if you're right. Sometimes you might take a bad deal because you need the money or it costs more to fight it. But say you did take this all the way to court, whatever the dispute may be, there are certain things that'll happen. We'll go over this a little bit later in the presentation. But generally, courts try to push people to settle as quickly as possible. Litigation takes a long time, and courts like disputes to be settled quickly and out of court. Traditionally, what have courts said about missing terms? Well, if the term is important enough, a court might say that a contract wasn't formed because there wasn't a substantial enough agreement between the parties. Terms such as scope of work, price, and time are the big ones. If those aren't specific enough, a court could say that the contract doesn't exist. Of course, this does open up a significant can of worms to, time, money spent. What if the terms weren't so important? Courts can make up terms. They can make up terms in a manner that they saw it was fair to both parties, but this is just hypothetical. In most contracts, there are dozens and dozens of general terms, and those terms relate to at least some part of the project. This is because there's a ton of contracts that go downstream with tons of subs. Just make sure that your part that you're on is specific enough so that you know exactly what your job is, what the price and the time terms are. And this could be a situation where you can negotiate with the prime or a general. On the other hand, it could be a term coming from the owner that you can't negotiate. Bottom line, just make sure you understand the contract. If it's vague, then ask why it's vague. If there's nothing, there's nothing wrong asking an upstream party to explain or list a term in more detail. I'm sure you've seen these contracts that are hundreds of pages long, and in a perfect world, you'd understand all the terms and a lawyer would have gone over them to make sure that you're covered. But the reality is the time is short and lawyers are expensive. So the key is just manage your risk. Is the specific term worth looking to or not? Yeah, that's a call that you're gonna have to make on the spot. So I hope that answered your question. We'll go into a couple more important topics right here. Victoria, if you could please pull up the first poll question. I'm going to be going over some of the important terms, and then we'll quickly go through what a sample contract looks like. And this is for people that may have not gone over a contract before. If you have, if you're very knowledgeable in contracts, then just go along. We'll go through this pretty quickly and get to some more of the more important issues. So the following contract, when I put it up, it's very simple. Actual contracts are very in appearance. We went over this yesterday. There's certain form contracts. Just make sure you understand everything. It's probably the 10th time I said that, but it's one of the most important things in construction. And then retain an attorney to ensure that you understand all the terms. So let's go over some of the typical clauses. If Victoria is the poll.
I have it completed, and let me read it off to you. 29% said none, 7% said 1 to 2, 21% said 3 to 4, and then 43% said more than 10.
Okay, we'll go over quickly, but I still want to go over some of these details so that some of the people that have not gone over a contract or are going over very few, this is a time where you can get a little bit more experience with the contract. So go over some of these terms. Some of them are very simple. Some of them may be a little complex. I'll try to make them as understandable as possible. Obviously, scope of work. This is what your job is. This is what you bid on. Know it. Time. This is obvious as well. There's a time frame that you have to do your contract. Price. Again, obvious. Payments. Progress payments. Final payments. How's the payment structure? This can get tricky if there's delays, but know what those procedures are. Pay when paid. The Prompt Purchasing Act in Ohio sets out those prompt payment rules, so you don't have to worry about that too much. Remember, retainers in Ohio is 8%, but it can be more. 8's just the lowest. Generally, it's around 10, maybe a couple points up. The owner and contractor representations. This is the section that you guarantee that you know what you're doing. The contractor responsibilities. This is also in the terms and conditions in the subcontract agreement that we'll go over. Those are just lists what your responsibilities are. Warranties and guarantees. Ohio law imposes an implied warranty on contractors that their services will be performed in a work-like manner. What does this mean? It means that if you don't do quality work, you can be forced to fix it or be forced to pay someone that can do it correctly. There are also general warranties that are included in the contract that all items furnished and installed by the contractor will be new unless otherwise specified and free of defects in materials or workmanship. Quality standards. This is a big one. There could be specific contract clauses that list out the quality of a project depending on what the project is. Now, there's some specific industry standards that are quantified by organizations such as ISO. There's a few others out there. You need to know what those standards are, and you need to know how to make sure that you reach those standards. Many large contractors have a quality assurance program to make sure that goals are being met along the way, and that quality is being met in every step of the project. Permits, pretty self-explanatory. Most of the time you have to get them on your own. Conditions of the worksite and safety. This is in every contract. This is also, state and federal regulations. We'll be going over OSHA and Department of Labor a little bit later on. Those are really important ones to make sure, safety is usually number one. You don't want to get violations for dumb stuff. Flow down clauses or flow through clauses. We just went through that in that question. So let me expand on this a little bit more. So the purpose of the flow down clause is to bind the subcontractor to the terms and conditions of the prime contract. Again, that prime contract is the contract between the owner and the general contractor. So here's what a typical flow down clause sounds like. So if you see this language, say, oh, there's a flow down clause, maybe I should look somewhere else in the contract documents to make sure that I know my specifics. So the contractor shall assume towards the subcontractor all obligations and responsibilities that the owner under such documents assumes towards the contractor, and the subcontractor shall assume towards the contractor all obligations and responsibilities which the contractor under such documents assumes towards the owner and the architect. The contractor shall have the benefit of all rights, remedies, and redress against the subcontractor that the owner under such documents has against the contractor, and the subcontractor shall have the benefits of all rights, remedies, and redress against the contractor that the contract under such documents has against the owner insofar as applicable to the subcontract. Now, that sounds confusing and vague. It is. But even though it's vague, it does something what's called incorporation. It incorporates or it references other documents into that clause. So while it's vague, it points out that other obligations are listed somewhere else. So case in point, find those terms. Don't be afraid to ask what they are. Design versus performance specifications. Here's another important clause I want you to understand. A performance specification sets forth the standard of performance to be achieved. The contractor is expected to exercise its judgment in how best to achieve the performance standard. A basic example of a performance specification is a specification that states the contractor shall construct an HVAC system that shall maintain a certain level of temperature and humidity. But it leaves the design of the system necessary to achieve the required temperature and humidity up to the contractor performing the work. Conversely, a design specification describes in detail the materials and equipment the contractor must use and the manner in which the work must be performed. So design specifications state how the contract is to be performed and permits no deviation. Performance specifications, on the other hand, specify the results to be obtained and leave it to the contractor to determine how to achieve those results. The distinction is critical because when a contractor agrees to design a system to meet a performance specification, it warrants that the system will perform as promised. And then conversely, if a contractor is on a design system that's simply to meet the design specification guidelines, there's no warranty that the system will perform in any particular way. So a contractor who's constructed a system according to a design specification has a defense to any claim that the system is not performing as intended. Change orders, we'll go over the, yes?
I've got a question that came into the question box. It says, many contracts I've reviewed state that if the prime contractor is not paid by the client, the prime is not obligated to pay the subcontractor. Is this true?
I'd have to see the exact language in the contract, but under Ohio laws, the Prompt Payment Act usually covers that. If you're paid, you have to pay it downstream. I'll check. I'll see that exact question and I'll address it after this presentation. I just want to keep going so we don't run out of time here.
Nope.
Time of the essence clauses. Those are important to understand. If there's a time of the essence clause, then if one of the parties of the contract fails to complete the work by a specific date, then the other party can treat the contract as terminated. There will usually be a clause specifically stating the time of the essence. Think of stadium construction and an upcoming sports season. Teams can't play if the stadium's not built. So typically on construction contracts, time is not of the essence, but rather completion date is set. And there are mechanisms that allow for the completion date to be adjusted, change orders and whatnot, and liquidated damages can be claimed if the client delays the fault of the contractor. And then vice versa, if it's fault of the owner, then the contractor or the subcontractor is entitled to liquidated damages. However, the contract is not terminated because that's usually just not in the best interest of either party. And then dispute resolution, alternate dispute resolution, we will go over that in just a little bit. I want to switch and go over for a few minutes just to show maybe some of those who have not seen a sample subcontracting agreement. Several, the subcontracting agreement or the contracting agreement, the actual agreement itself is sometimes really short. The general conditions and the specific conditions will be far longer. numbering into the tens, dozens of pages, even into over hundreds of pages. So generally it's the work, the scope, in an exhibit, the time, and the price that goes into the first part of the agreement. So as you see here, Article 1, it describes the work. Generally, it's a very vague term that usually says see attach Exhibit A as the scope of work, which will in more detail list what you got to do. Contract time, always make sure to go over this, know what your time frames are. I'll repeat that several more times today. Contract price, you know what it is what you bid on. Change orders, make sure you know the procedure, know how to do them, know who to contact. Contract documents, you're going back, know everything that's in the contract documents. If something's vague, it's usually somewhere else, so make sure that you find where it is so that there's no confusion. If there's confusion, it leads to mistakes and disputes. Payment procedures, in Ohio, it's a little bit more set because of the PPA. So the law actually forces money to go downstream. But look at different payment terms as it relates to progress payments and payments as far as percentage goes. Final payments, also, these are just generally set industry-wide. Final payments done after the completion of a project. That's after all the reports are done, all the subs are done, all the as-built are done. That's when everything closes out. So, and that can take some time too. So make sure that you know what has to be completed to get a time frame on that final payment. Interest, I know this one says no interest, but remember Ohio has 18%. Here's the subcontractor's representations. This is what you represent that you can do, is that you can do the job right. They can do it in a workmanlike manner. The responsibilities, also general permits, what we just mentioned before, those are going to be your responsibility, taxes your responsibility, use of premises, record documents. Make sure, document retention, document recording, that's one of your best practices. Where are you going to store them? What are they going to look like? We'll go over that in a little bit. Safety, like I said, we'll go over that in a little bit too. Some OSHA guidelines. Damage to the work, have some plans in place to try to avoid. Warranties, we went over warranties just a little bit ago, and then insurance will cover. Remember, there's going to be liability insurance, there's going to be workers' comp insurance, and then terminations of the contract. Generally, terminations come about because you damage something or there's a delay. Make sure you know the thresholds of the time that you have to fix something. So, delays happen all the time. I don't know if there's ever been a construction program that ended right, specifically perfectly on time without any delays, or if there were delays, they were made up. Know how much time you have to make up, and have those procedures in place. And then again, here again, we see the miscellaneous. This is the boilerplate language, the entire agreement, the choice of law. We went over this yesterday. Mediation, arbitration, we'll cover a little bit later. And then I said scope A, exhibit of work. So we're going to switch over to the general conditions. These are only just the titles. So the general conditions provide more complete contract terms and define the services that the contractor will provide. Notice that it's only the terms here. There's 6 pages worth in 2 columns. The general conditions document all of the terms. We'll describe all the terms. The actual document could be up to 100 pages, maybe more. Notice a lot of these terms are also in the contract that we just went over. They can be interchanged and regularly are, and it can be interchanged with the special conditions. Every project will be different, every contract's a little different, but rule of thumb is that main contract will have the identity of the parties, the legal address, the project, the time for commencement and completion, the price and procedures of payment. The general provisions and special conditions will have everything else, but there's nothing wrong with it when you see that some of these terms are in other sections. So again, I have to repeat, know your contract. You'll want to go over these to understand what things you might encounter or what things you didn't think about, on your project, or things that you may want to bid on in the future and things you have to take into account. So not everything, you're not going to have to take into account all this stuff, but know what's out there. So just want to highlight a couple of the important ones that I'd like you to watch out for, and maybe study all of these. It will take some time, but accident prevention, know what specific takes you have to take for accident prevention. You don't want to see safety violations or be removed from the project. Bidding requirements, you know what you have to do. You know what the rules are, and make sure you follow them so you can get an actual chance to land a project. Change orders, know the procedure. Claims and disputes, again, know the procedure. Contract documents, again, this will list out where all the information is, or let you know where the documents are that make up the contract. If something sounds vague, then it should be described better somewhere else. If you can't find it, ask. Contractors' right to stop work. Remember, Ohio law is silent on stop work. Generally, you don't stop work. Generally, you keep working. Claims are handled afterwards. We'll go over that in just a little bit. Delays and extension of time. Know what the guidelines are. Know what the threshold is. Know how much time you have to fix something if you're delayed. Damage to work. What's the procedure? What's the communication procedure? The governing law. Went over that yesterday and just recently. Remember that the general contractor or the owner, if it's listed that any lawsuits or arbitration have to be in the city where the project is, where they're based, they have home court advantage. Indemnification, know what you're voluntarily covering for someone else if something goes wrong. Insurance, know what the insurance requirements are. Liens, understand if there's any special terms. We'll go over liens a little bit later. Generally simple procedures, but just know if there's any deviations. The owner's authority and the owner's relationship with the subcontractors. You probably won't be communicating with the owner, but understand there might be some issues. Say you're doing part of a project on a performance specification term that you have with the prime or the general. The owner might want something done in a certain way when the decision's actually up to you. Know what the communication procedures are, and know what the owner's authority is as it relates to you.
Pat, we've got another question.
Okay.
It says, if a prime contractor requires a bond, are they still permitted to withhold retainage?
I do not believe so. That's required by law. They have to, like I said, the minimum is 8%. So that's actually separate from being bonded. It's a separate term. So the retainage is apart from that. So they're still bound to hold 8% back under Ohio state law. Protection of property and equipment, going back to safety. You don't want OSHA to ding you for something that might have been relatively cheap and simple. Going back to yesterday's tower crane example, how much do you think those polyester slings cost? A couple $100, maybe less. How long did it take to install them? A few hours max. That could have been the difference between a successful project and the loss of life and a $50 million mistake. Make sure your safety regulations, your procedures, and then know all the state, local, and federal laws. Retainage, for example, like we just mentioned. Rules for arbitration. Suspension by owner for convenience, termination, time delays, unforeseen conditions. We don't have time to go over all of them, but just want to make sure that you know what exists in the contract. You know what you're going to have to think about. You're going to have to understand all these, and you're going to have to know what to do when you're bidding or when disputes come up. So special conditions. Just want to give a couple examples. These can also be called supplementary conditions. The general conditions are often the standard industry in a form. Since construction contracts vary by locality and project type, special conditions might be added to modify, clarify, or supplement portions of the general conditions. Again, these might be found, some of these terms might be found in the general conditions and vice versa. I'm only going to go over a few in the interest of time. Utilities, do you need access to electricity, water? If so, how much? What's the cost? You got to know how to, plan for that beforehand in your estimation and your bidding. Cold weather protection, what are the guidelines? It gets really cold here in Ohio. What's the cost going to be? What precautions need to be taken? Weather protection, same. Snow removal, same. Signs, there may be local laws and signs you have to abide by. I know OSHA, there's a ton of violations for not having enough hazard signage, whether it's for your workers or for the public. Watchman security services, do you need these, and who covers the cost? There might be some very expensive material laying around for an extended period of time, unused before you use it. Punch list, the procedures for these, safety meetings, what are the requirements? Hazardous materials, what are you going to be working with? Are there other special procedures? Big one, non-smoking facilities. Is the work being done at a school or a hospital, or other non-smoking locations. Lots of contractors smoke, so know where your workers can go smoke, or give them rules. Noise controls. Are you near a residential area? How do you accomplish this? Diversity inclusion reporting. This goes back to best practices, maintaining good records. So these are all stuff you have to think about. I'd like you to take some time and go over each one of these. If you can get a sample contract or a sample form, just understand the terms. Understand that what you're going to be dealing with. Understand the entirety of your job or the job that you want to bid on. It is going to take a while. There's too much information to go over quickly. But this is your career. Go over it. Understand everything. It'll do you right to know what you're talking about, and you'll be able to make better estimates and bids and work on bigger projects. So we're going to move on to indemnity and liability. Indemnity, what is it? So an indemnity or hold harmless clause are a section of construction contracts between two or more parties, typically the property owner and contractor, or the contractor and subcontractors, regarding the responsibility of losses or damages during a construction project. An indemnity clause provides protection to a specified party of the construction contract against damages and exempts them from liability caused by their own actions. In simple terms, this clause holds one party harmless for the loss of another. An indemnity clause may protect an owner or general contractor from the liability to the extent that someone's injured on the owner's property during a construction project, namely your worker. You need to make sure that your contract includes these indemnity clauses that protects your interests, whether you're upstream or downstream, or just keep in mind that you might not have enough leverage and the risk may be placed on you. Just know what that risk is. Know where it's coming from. Liability, very similar. It's the state of being responsible for someone else by law. You'll always want to limit your liability for the actions or inactions of another. There are limited liability limitations clauses in contracts, and you'll need to know where your liability is. So other important terms and conditions as they relate to U.S. Department of Labor requirements. Just want to make sure we go over a couple of insurance, liability, and workers' comp stuff. Insurance and workers' comp both required. Know what the exact requirements are, because if you don't meet them, you'll be disqualified from bidding, or you just won't get chosen. Remember, the cost is part of the estimate. Make sure you include that. ODOT has its own insurance requirements. Private contracts will have their own insurance requirements. ODOT, they'll be listed on the website and then invitations to bid. Same as private contracts. Familiarize yourself where to find them. In the United States, workers' comp is compulsory. Workers' compensation is an insurance that provides wage replacement and medical benefits for employees injured in the course of their employment. So you'll be responsible for covering that. And there's many Department of Labor requirements. There's federal regulations that need to be followed, or you could be found in violation. There could be enforcement actions placed on you by the Department of Labor. If you're a willful violator, you could be facing both not only civil claims, you could be facing criminal charges if you mess up too many times or just completely disregard the federal laws. Yes, you could face jail time if you are going against the federal regulations. So make sure you're not doing this. That'd be a dumb reason to face criminal charges. Some of the simple ones are posting requirements that you need to have in your place of business. You've seen these, like the minimum wage posters that are up at the water cooler. You can get fined if these are not up. Can lead to many different consequences. So the best way to address these is to contract with a human resource professional. You can hire one full time. You can contract one to consult you on hiring policies and your workplace environment. Understand that when you're hiring people, that there are certain things that you can't ask in interviews, certain things you can't say in the workplace. Managing your risk as it pertains to like an employment-related lawsuit is going to be another one of your best practices. Make sure HR guidelines are in place to save you some heartache. So, where do you find an HR professional? Any of your local universities, colleges, career centers can help you. ODOT can help you. There's national human resources organizations out there. The Society of Human Resource Management is one. I believe that's the biggest. They can help you find human resource professionals. There's several more out there. Victoria, if you could put up poll question number 3, please. So I'll just go into it. Whether you know or not, the EEOC is the U.S. Equal Employment Opportunity Commission. It's a federal agency that administers and enforces civil rights laws against workplace discrimination. The EEOC investigates discrimination complaints based on individuals' race, children, national origin, religion, sex, age, disability, sexual orientation, gender identity, genetic information, and retaliation for reporting, participating in, and or opposing a discriminatory practice. It was born out of the Civil Rights Act of 1964. Are we to the?
Okay, Pat, I did not put up the EEOC question. I put up the one about, have you ever had to sue someone or have you been sued yourself? And the answers were 41% yes or 59% no.
Okay.
Sorry about that.
No, it's okay. Put that other one up. I'll address it. And let me write this down for a second. Can you put the EEOC one up? It's no problem. I think that might have been, I think that was my mistake.
It's okay. I've got the EEOC one up now, but.
We'll address it when I come to the litigation concerns.
Sure.
So we'll just keep going through it. So the EEOC, the regulations, they apply to private employers who have 15 or more employees that work 20 more hours a week. You must treat all people fairly, regardless of national origin, race, religion, color, sex, including pregnancy and sexual orientation, disability, or genetic information. The classes are expanding. These are called protected classes. Remember that word, you'll hear it.
Yeah, 68% said that they know their company is subject to EEOC, 25% said no, and 7% said what is EEOC? Okay,
perfect. These are just federal regulations that, are mandatory to comply by. You can be sued by the federal government if you're not following these. So if you have more than 20 workers, age discrimination also applies. You must treat someone over the age of 40 the same as a younger employee in decisions of hiring, promotion, and termination. And this is big in contracting because, obviously at 40, everything hurts. You're not going up the ladder as quickly as you used to. Kids that are 20, 25 years old that, a lot quicker, a lot more energy, even though they don't know as much, they might be a little more productive when they're swinging a hammer. So these are things that you have to actually think about. And again, these are things that you should talk about with an HR professional that knows those rules and regulations in a lot more detail. Excuse me. So the EEOC guidelines, it extends how employees treat each other. An employee cannot harass another employee because of national origin, race, religion, color, age, sex, disability, genetic information. A zero tolerance policy should be instituted. You can be liable for maintaining a workplace atmosphere that allows this kind of behavior. Just no reason to have it. Record keeping for employees, keep employee records for a year after termination. Keep your posters up when you're putting jobs out there. Include the required tagline, EEOAA employer, that's equal employment opportunity, affirmative action employer. And have an HR professional on staff or on contract to notify of any changes in the requirements. They do change. Say, I repeated that once again, must mean it's important. An employment-based lawsuit can bankrupt the company and lessen your chances of landing any public contracts. Most agencies and private actors don't want to be seen to be doing business with someone that has these kinds of employment violations. Making sure you have the right policies in place can save you, could be the other most important. Red flags in contracts. Now, I just want to go over a few. We've already gone over a bunch. Just want to repeat the important ones. I just wanted to go over them again to hammer it home. Vagueness in contracts is bad. Vagueness in time, requirements. Vagueness kills a contract. Courts can declare a contract void for vagueness. The contract should spell everything out in plain English. Don't avoid a clause because the language looks or sounds tricky or if you don't understand it. Sometimes, shady lawyers will write things very long and confusingly because they can add it to their billable hours. They make things so confusing you can't make sense of them. I don't think this practice. I don't like this practice. everything should be written as clearly as possible. There's no reason why you need to make something more complicated sounding than it needs to be. So if you see some of this confusing language, make sure you get to the bottom of it. Look over for the absence of specific clauses. We've gone over a couple today. Absence of any required terms. If something is missing that's obvious, there's probably going to be little other less obvious things that are missing. You don't want someone to try to take advantage of you by leaving things out or writing things in a contract in a tricky manner. The change of work details, make sure you know the procedure. If there's no damage for delays, delays happen all the time. There's always damage language. There's not in there. There might be something wrong. Vague change orders, be careful of those. Condition precedent to get paid. Other functional requirements to getting paid. The payment terms should be clear and easy. Obviously here we have the Prompt Payment Act, so that should be followed. Again, anything you'd understand because it's written confusingly, and always have an attorney review prior to your signing the contract. No blank pages. If there's a blank page, make sure it says page left specifically blank or intentionally blank. Make sure that even though the contracts are hundreds of pages long, make sure that you and the other party initial and date every page. And you keep a copy of it. This goes to any disputes that might happen in the future, and the other party will say, "Oh no, I don't remember this. I didn't agree to this." And you can pull out your copy and say, "Look here on page 32, you initialed this page. This is where this dispute is." So goes back to good record keeping. Changes and breaches. Excuse me. Take a sip of water real quick. So it's rare for a construction project to be built exactly as originally designed. Some changes are simple, like changing the color of paint before it's been ordered. Other changes can be drastic, which requires a formal process to be followed. Generally that process will be laid out in contract, and it's pretty much the same industry-wide. The changes clause usually allows changes to be negotiated under the terms of the contract rather than doing a separate contract as well. So our changes anticipated, contemplated, and reported. Generally, a contemplated change notice is filed beforehand to deal with the change accordingly. If it's done afterwards, it's a claim. Generally, if it's done after the facts because something deviated from the contract. These documents, the actual document will list the changes, the cost, the time. The claim is filed after the work has been completed. Most contracts you just can't stop working. Just deal with it after the fact. This happens all the time. It's not unusual. How are they initiated? They go both ways. They can happen before a certain event. They can happen after a certain event. The bigger the change, obviously, the more complex and time-consuming the process will be. What if the changes are out of scope of the project or not contemplated? Now, this is another red flag. There'll be some issues because generally changes are allowed only to be made under the scope of the prime contract. That's because if it's out of the scope, then there wasn't really any agreement in the first place. And make sure to document everything extensively. Now, I was talking with Joe Lopez last week. His brother's a contractor out in New York, working on a big project and talking about claims. He's working on a project at the Port Authority of New York and New Jersey, working on a project, I believe, that was somewhere around $10 billion. That's B with a billion. You have thousands of people working on these. So there's a lot of moving parts. So his specific issue, they were working on renovating or adding some railways. They're actually doing the physical work, the structural engineering stuff, but they couldn't work if there weren't flag people, at intersections, at certain locations that were required by the safety regulations. So I know he had several hundred workers that would show up at 6, 7 in the morning. However, the flag workers, who were the responsibility of the owner, they didn't show them until later. So there'd be days where Joe's brother's workers couldn't start working for a couple hours. So there's lost productivity. These are delays caused by the owner. So what happens? Everything was recorded extensively. Who was delayed, how many minutes, what was their name, what was their project. All this was documented. And after the project was completed or concurrently, the claim was issued, and it ends up being a couple $100,000. And you're talking about huge projects here. So, remember, how do you prove lost productivity? Document everything. You can also get administrative costs back for having to calculate everything. It takes time. It takes hours and hours and hours to see how much you actually missed and lost productivity. So make sure that the change orders or the claims are specific and detailed. Yeah, don't do any work until a change order directive has been signed by the owner or someone who is authorized by the owner. Going to authority, in large complex projects, there'll be a lot of people doing different things. There'll be the general contractors people, other subs, foremen, inspectors, state or federal employees, superintendents. Everybody will be doing something different, but in conjunction with each other. Some people have authority to direct work and workers, and others do not. You need to know who has the authority to do what. Authority comes from something called agency law. An owner or general contractor often relies on other employees to conduct business. The person that's authorized to act on the behalf is called an agent. As I said, they can also have different titles: superintendent, foreman, whatever it may be. There's three types of authority: actual authority, apparent authority, and ratified authority. Actual authority, there's two kinds of this. Express authority, you've been told that an agent has authority. Or implied authority, you can imply that someone has authority. We'll just say, equal partners in a general contracting firm, because they hold ownership in the project. They have the authority to direct work. Apparent authority exists where one can reasonably believe that another person has authority. Apparent authority exists where a principal's word or conduct could lead a reasonable person to think that a third party's position has authority. So this is similar to like when a general contractor appoints a foreman or a superintendent. Doesn't explicitly say that they have the authority to do anything, but generally they do. Ratified authority, you really won't run into this, but this is authority given after the fact. So why is this important to construction? With so many people, on a site, things get congested, and you don't want a superintendent or a foreman causing you loss of productivities, delays. If you're telling workers to do something a certain way, you need to find out who has the authority. And what to do to avoid situations or confrontations with people that may or may not have authority. Communication policy, internally written externally.
I've got a couple questions here for you. The first one is, what is a waiver of subrogation?
I'm running low on time. I still have a lot to cover. Write these down, and I'll answer them afterwards. I just don't want to miss out on
no problem.
Okay. So communication policy goes hand in hand with good record keeping. These should both be in your best practices. You can look at an internal communication policy as a chain of command and procedures for reporting normal and abnormal incidents. You should have daily reports of what was done by who and at what time. You need to identify the person that would make the report, even if it's you. And the reporting procedure needs to be the same every time it is done. The report templates that you can find or purchase that might make it easier, or you can do one yourself if you have a certain way you want to report progress. There should also be a procedure of when things go wrong, whether that be accidents or damaged work or other incidents. You need to have both a separate reporting policy and a separate communication policy. So the communication policy externally will be what's communicated outside of the company. There should be only one voice coming from your firm when something doesn't go according to plan. You don't want differing stories or reports being out. You want to make sure the person communicating knows what they're doing. That'll usually be you or one of your partners, BL partners. And you should have listed who you need to tell upstream and what parties to contact. Remember, write everything down, summarize at every job meeting, at weekly meetings, put it on the general contractor's record. Just make sure to get it on the record. So scheduling issues, delays, so I've gone over it, but I want to go over it again. Delays can be characterized as either inexcusable, compensable, or excusable. A delay that is caused by or within the control of the contractor or subcontractor is an inexcusable delay. In these cases, the required completion date is not extended, and the contract may incur liquidated damages. We'll go over damages in a little bit. If the delay is caused by the owner or the general contractor, the delay is considered compensable, and the contractor is entitled to both a time extension and compensation for any costs incurred as a result of the delay. Excusable delays are caused by events beyond the control of the parties. Think COVID-19 or other acts of God, earthquakes, other pandemics, strikes, freight embargoes. Usually the time of completion is extended, but no damages are assessed because it was out of the control of either side. So just make sure you go over the contract requirements, work times and commencement dates set on the first page. Keep notice of commencement in mind. Any unforeseen delays can be rectified by a change order. Understand the threshold for delays on a project. I mentioned that. Know how long you have to fix it. Be careful for delays because of the contractor, lead to damages. What do you got to do to get the project back online? And what happens when a sub is removed or fails? What are the repercussions downstream? What are the claims? Everything's sequential. So, make sure that everything's reflected and refer back to the contract for any guidance. Breach of contract. Breach of contract is the legal term that's used when a party doesn't abide by the terms set forth in the agreement. What are the first moves you should take? It depends if you're upstream or downstream. If it's a small breach, try to fix it in the time frame allowed. As I said before, know the thresholds. Generally, you want to do everything that you can to cure, any deviations. Deviations happen, and you want to minimize the risk that there'll be litigation or that you'll be removed from a project. What if it's a big breach that can't be cured within the time limits or cured at all? You may want to have an attorney communicate the breach and what the next steps are if it's a big one. This incident might lead to litigation, and your statements could be used against you. You don't want to accidentally say the wrong thing. Like I said, we're talking about big projects, ones that you don't want to encounter. Everybody wants to get everything finished as pain-free as possible because that's where you make your money and move on to the next. But you don't make money from mistakes, and just understand that things may be used against you in your own words. So who should you call? Attorney. And if it's something smaller, you can call the bond company. The bond company can sometimes put pressure on an upstream party for payment. So at this point, I was going to put up poll question 8. Have you ever been sued or had to sue someone? I believe the percentages were 49% yes, 51% no. So litigation concerns, you never want to get here. Litigation is expensive. It keeps you from doing work, causes stress, loss of money. We always want to avoid it. It's timely, expensive, and if you're just starting out, you probably won't be able to afford litigation. Do everything you can to avoid coming to this point. Even if you owe a lot of money for some deviation, damage, incident, keep in mind that you could end up spending more than double or triple on lawyers and litigation itself, and then still end up having to pay what you owe. You could also run into a situation where you run out of money halfway through litigation and you can't pay your attorneys, and attorneys don't work if they're not paid. So, avoid this situation at any cost. Then realize too that as you progress in your career and as you become more successful, you'll probably get sued by parties upstream and downstream. Seasoned contractors are all too familiar with the legal process. Comes with being in construction, so get used to having to deal with lawyers and lawsuits. And I think that's represented by 51% of the participants, having litigation experience, and it's just a fact of life. So quickly go over some statute of limitations, and then I'll go through the life cycle of the lawsuit for you. Statute of limitations is how long you have to bring a claim, how long you have to bring a lawsuit. For written contracts, private contracts, those are 8 years that you can file a lawsuit. For money damages, breach of contract, implied or oral contracts, 6 years. These are the small jobs, fixing someone's bathroom. Against the state of Ohio, it's only 2 years. So if there's some issues, you want to make sure to take care of those issues within the 2-year mark. Time begins to run at the completion of a project after everything's done. Statute of limitations for bodily injury or property damage are 2 years from its occurrence. Professional malpractice by design professional. This is, say, an engineer designs a bridge. It's constructed to the design specifications. The bridge fails, but not because of the contractor's work, but because of the design. There's no limit. You can always sue a design professional for any of those problems. Latent defects, those are defects you can't see or you don't find out. There's also no limit to those. And remember, architects, engineers, they have professional insurance to cover them for this. So don't be scared if something's their fault to get upstream. So litigation in Ohio, who can bring an action in Ohio against an individual or a company? If that individual company is a resident of Ohio, if it's incorporated in Ohio, if it transacts business in Ohio, if it causes injury in Ohio, or if it agrees to be bound by Ohio laws. So how do lawsuits last? It's not a quick process. At the very minimum, lawsuits will last several months. The ones that last several months are because the parties settled early. Each lawsuit is different, so there's no way to really tell beforehand what the proper course of action is, how long it's going to take. They can last up to 10 years, even more with appeals. So how does it start? Usually the first step is a demand letter. A lawyer sends a letter to the opposing side detailing the reasons for a claim. Now, this is outside the judicial process, but it's always the first step taken. It's always easier to settle a case beforehand, out of court. It's just quicker and more painless. So if no settlement can be reached, then a complaint is filed in court listing the reasons for the lawsuit. The person making the complaint is called the defendant, obviously through their lawyer. The complaint is filed with the court, and a service or notice is sent to the party getting sued, usually at their principal place of business. The party getting sued, they're called the defendants. They actually have to get notice they're being sued. Once they get notice, they have 28 days to respond. Usually the response is a general denial and lists any defenses that they may have. Then it becomes a paperwork battle between the lawyers who try to get the complaint dismissed or won on certain technical issues and points of law. Now the courts are really clogged, and we're a pretty litigious society, so there are tons of cases. So the time frame for civil litigation is long. After the initial filings are done, it can take 3, 4, 6, 8 months, maybe a year, no kidding, before you even get into court and see a judge. That's not abnormal. And the meter keeps running on the attorney's fees the whole time. And you'll be busy with new projects, doing different jobs. The next step is called discovery, and this is all the information gathering. You ask for documents from the other side, they ask them from you. People are put in depositions. You get asked questions under oath. It's a very nasty situation. No one likes getting deposed. Once everybody has everybody's information, all their documents, then the lawyers battle again through paperwork to see if they can win. If they don't win, then you finally get in front of a judge to schedule the trial. You can be 6 years in, 7 years in, and trials can be scheduled a year or more out. Lawyers can charge anywhere between $200 and $1,000 an hour. Litigation costs easily to the hundreds of thousands to the millions of dollars. Moral of the story is, use your best practice and do your best job. No one's looking to litigate, but it still happens. Damages, most common is liquidated. What's liquidated damage? So in lieu of actually calculating damages, usually for delays, the parties will negotiate a per day charge that will be assessed. This keeps it simple. Remember, this is done beforehand, and the courts will enforce liquidated damages as long as they're reasonable. There's no intense litigation needed for liquidated damages. Compensatory damages, this happens when sometimes people are hurt or if there's expectations. Punitive damages are made to punish a party for taking some action that just is kind of a shady action. Equitable remedies, specific performance. In some certain issues, you can get paid. You can get forced to have to finish something, or the contract can be terminated. Economic loss rule. I'll go quickly. This is, you won't likely encounter it anytime soon. This is for complex litigation. Simply put, it puts a limit on the amount of damages that a party can receive. The purpose of the rule is pretty simple. It's to prevent parties from expanding the scope of the bargain for remedies or damages under a contract. It's crafty lawyers trying to sue for more than what was originally contemplated. Dispute resolution, similar to court, but a lot quicker. A lot of benefits just in terms of speed and attorney's fees. Arbitration is where an individual, usually a retired judge or a very experienced attorney, is appointed to serve as judge and jury. The initial steps are the same. Discovery, documents are exchanged, people are deposed, and then there's a very short trial in which the arbitrator makes a decision. Arbitration is binding, meaning that the court will enforce the decision. Mediation is structurally it's very similar. However, generally the difference is that mediation is not binding. They just want you to come to a solution. They're also hired by the parties. Dispute review boards, these are negotiated beforehand. If this is a way, there's a board of people that you can elect to resolve issues. If there's smaller issues, you can talk to the bond company. The bond company can pressure a party into payment. Construction liens, what is a lien? A lien is a legal hold that is placed on the title to a particular property as security for debt. The most common example is your mortgage. In construction, they're called mechanics liens, and then subjective means to get paid. The lien creates a cloud on the title and makes it difficult for the owner to sell the property. So there are two steps to creating an enforceable lien. The first is attachment, and this arises automatically when you actually do the work. The second part, called perfection, is where the legwork comes in. Generally you have to give a notice of furnishing, and then you need to record your lien at the county recorder. The actual document has to have all the information about the property, the work done, the money owed, needs to be notarized and recorded. Remember, just because you have a lien doesn't mean the job stops. This is just to secure your payment if you haven't been paid. Risk management. Do you have a risk management plan? If you don't, you should. This was going to be a poll question, but I'm getting a little short. Make sure you have a plan that contains, all your corporate safety policies, risk management positions, any violence, sexual misconduct policy, other policies, any policies that OSHA puts onto you. What's OSHA? It's the Occupational Safety and Health Administration, part of the Department of Labor. Know the regulations. Make sure the regulations are part of your risk management plan. Your safety. What OSHA's most cited violations? Problems in scaffolding, fall protection, hazard communication. Those are your signs. Respiratory problems with someone not wearing their face mask. Don't think that's a problem right now. Electrical wiring, ladders. Get to know where the violations occur and know how to avoid them. Licensure. Ohio law requires that the following construction-related professionals be licensed to practice as your architects, landscape architects, engineers, land surveyors, certain commercial contractors, HVAC, refrigeration, electrical, plumbing, and hydronics. If you're in that latter, just know those professions need to have licensure. Construction accidents. Now, before COVID-19, I wanted to go over some of the large construction accidents and do a case study on what went wrong and why. Originally, we would have had more time together to do this. So, hopefully next time that we see each other, I can dive a little deeper into some of the specifics. The bottom line is that you're going to want to have a plan if something goes really wrong. What do you do in what situation? Who do you contact? How do you minimize your risk? My advice would be to study previous accidents. You can find information written, you can find information on the web. Do your own case study. Figure out what went wrong. Figure out why it went wrong. Were there the certain safety precautions up? Were they not? What happened after the fact? Use people's previous decisions and use previous examples to guide you, in your career in situations like this. Crisis management plan, part of that same, have a first contact list. Who do you contact first? Chain of command, statements made to the public, to the authorities, contingency plans, legal steps, other issues. These can all be found out by running case studies. A couple of miscellaneous topics as we close out the hour here. Remember there's different regulations between Ohio Department of Transportation and private contracts. You find all this on the ODOT website. As you start progressing a career, understand project delivery systems and how contracts are entered into with multiple entities. Look into it. I don't have enough time to explain it right now. We went over industry standard forms, the most negotiated prices, implied warranties. We did go over that. The Little Miller Acts, what the bonding requirements are. Always remember to review what the bonding requirements are. Equipment sharing as it pertains to Department of Transportation. Not allowed to share equipment if you're going to bid on a project for Ohio Department of Transportation. This is different if it's private. Make sure that you know what those regulations are. It'd be a good idea to go over the ODOT Construction Administration Manual Procedures. This document is a 1,000-page long document with professionals that update it every 2 years. It is very detailed on all procedures you need to take. Become very familiar with it. They lay out the regulations, and the more regulations the better you know them, the better you are at being able to bid on a project. Really spend some time with the ODOT website. It's a fountain of information that you should want to study. Finally, best practice to follow. Have a folder of best practices. We went over a bunch of them today. Think of them as checklists to follow as you go along. Document your flow of work, maintenance of records. With that, I'm running out of time. I hope you found a lot of this information useful. I will answer all of the questions that you pose after this seminar, and I hope you're looking forward to Mr. Luis Cartagena's presentation on accounting as it relates to construction contracts. So thank you for your time. I really appreciate ODOT for giving me this opportunity. You guys have a wonderful rest of your day. Thank you so much.
Thank you, Pat. And I just want to encourage everyone to remember that this is training that you can use as a reference. You know, I know there's a lot that's been shared this morning. So you have to, of course, take life one day at a time, and as we're doing right now, but please make sure that you keep this information and keep it as a reference for moving forward. I will send the questions that were put in the chat pod over to our presenter, and then we'll get the responses to those questions out to everyone. I hope everyone stays safe and has a great rest of your day. We hope to see you on next week's webinars. Thank you.